Hello, everybody. Welcome to another episode of Seize Your Business and Learn About Law. You've probably seen this in some of the TV shows where they bring two shows together and the characters interact. So we're going to do kind of the same thing.
Sweeps Week crossover.
Yeah, Sweeps Week crossover. Exactly. So I'm Jim Wazak, as always. See me for supplemental cancer insurance. And my guest is also my co-host, Kevin O'Flaherty of O'Flaherty Law. So we'll jump right in.
So what we want to talk today about has to do with both our business podcast and our law podcast, so we thought it would make sense to combine them. I wanted to talk about employment agreements and independent contractor agreements. So a lot of times in the Learn About Law podcast, I have a tendency to monologue since I don't have a co-host.
Well, I won't let you do that.
So yeah, don't let me do that. Maybe you can ask me some questions. And
well, I'll start right out with one that I see a lot of small businesses do, and it always concerns me. But they're trying to be clever and avoid payroll taxes, so they think we're going to pay everybody on a 1099. Well, that's great, except it may not be right, because tell us the difference between what a person has to be to qualify as a 1099 employee.
Sure. So there's, unfortunately, and this is a real problem, there's no hard and fast rule for what constitutes a 1099 independent contractor or a W-2 employee. Now, business owners, if you can make somebody a 1099 contractor, a lot of business owners like to do that because there's less liability for their actions. They save on payroll tax. The problem is you can't just have an independent contractor agreement and call somebody an independent contractor and let it be so. There's a multi-factor test that Illinois courts use, and basically it comes down to one rule of thumb is how much control do you have over the way that the person does the job. So you want to find out, and I like to put it like this: does the person look more like the plumber that you have come in and fix your toilet once in a while, and they decide when they're going to do it, how they're going to do it, provide their own tools? Or do they look more like the receptionist who's got to be at your office 9 to 5 using your computer or using your phones? And if they look more like the receptionist, then chances are they're going to be treated as an employee. And you can, it's between you and your payroll company how you want to treat them for payroll purposes. But if you get audited and the IRS decides that you haven't been properly withholding these payroll taxes because you've been calling someone an independent contractor when they're really an employee, you could end up paying all that back plus a bunch of penalties, and it could be pretty much a financial hardship. So, there's a lot of factors. It's how much control you have over their hours. The more control you have over when they're working, the more likely they are to be an employee. How much control you have over how they perform their job. The more control you have, the more likely they are to be an employee. Whether you own the tools of their trade. So, for example, I own my receptionist's computer. I don't ask her to bring her own computer and phone to work. She's clearly an employee. But, in the construction industry, if you're hiring somebody to work on a bunch of roofing jobs, even if you hire them all the time, if they're bringing their own tools and they can complete the project whenever they like, as long as it's within a certain deadline, then you can make the argument that they're an independent contractor.
So you mentioned that they could be liable for the payroll taxes that they didn't withhold, but they kind of were liable for that anyway. But are there further liabilities? I thought I heard somewhere that if they're paying them on a 1099 and they really should be on a W-2, and if the 1099 independent contractor does not properly report their taxes, that they could be liable for that too. Now, is that an old wives' tale, or is that...
Well, so you're saying could they be paying not only what they should have been withholding, but also, whatever wasn't properly reported?
The employee didn't pay.
That's a little bit out of my wheelhouse. That's something that I wouldn't ask an accountant. What I can tell you is that if you don't structure it properly, it's not only going to be what you should have been withholding. There's going to be some penalties and interest involved. Yeah. So, I don't know exactly what those penalties and interests are. I do know that they're something that, we advise people to avoid. If you're not sure, whether if it's a close call between someone being an independent contractor and an employee, and you might want to roll the dice, I would say talk to your accountant about what the fallout could be from that.
Are there any workers' comp impacts? I mean, if somebody was a 1099 and they get hurt, are they still covered by workers' comp even though they're not an employee, or is that
that's
another
a good point.
hole?
That's where you can get really nailed.
Okay.
So, and I that was very wise of you to bring that up.
Well, thank you. Occasionally
as
have
much,
some good
as much as I hate to compliment
I
you.
know, it hurts, but you gotta do what you gotta do.
So we've had some clients that came to us with this problem, and it was pretty bad. So if you should be covering somebody's workers' compensation insurance and carrying workers' compensation insurance for somebody, and you're not, and they get injured, and then they make a workers' comp claim, then you have to pay this massive penalty, like $10,000, maybe more, just this giant penalty for not having the insurance. They're going to get paid out of a pool for that covers people whose employers don't have the insurance. So they're going to get paid, but then you get this penalty for not having the insurance. So the way that works in the independent contractor employee scenario is that you've got to cover all of your employees under workers' comp insurance. So, and a lot of people don't know this. They'll just kind of hire somebody and not think about it. So whenever I meet with somebody to set up their business for the first time, I'll say, you definitely need to come in and have another meeting with me before you hire your first employee so we can get you all squared away. You got to register a bunch of places. You have to get workers' comp insurance. But you have to have it for employees. Now, if you're kind of threading the needle between independent contractor and employee, you may be in big trouble if you call someone an independent contractor, don't carry workers' comp insurance. They're not carrying workers' comp insurance, and then they file a workers' comp claim. Now, if they're clearly an independent contractor, that may be their problem, but still, we recommend that if you hire an independent contractor, in the independent contractor agreement, you have them warrant that they're carrying their own workers' compensation insurance, because this can flow downhill. Because if they've got employees of their own and they're not carrying workers' comp insurance and you hire them as an independent contractor and the government decides, hey, you should have been covering this whole group of people for workers' comp insurance, you might be in trouble. So one of the key clauses in a worker or an independent contract is they're saying that we're carrying our own insurance. Now, even if they're not, at least they're making that warranty and they're on the hook for it.
Exactly. So the other similar sin, I want to get to contracts too, but since we're on this topic, people figure they're somehow pulling the fast one if they pay people cash, especially early stage business. I would imagine there's similar risks to paying a 1099 who should be a W-2, but...
Yeah, I mean, everything's great if you don't get caught,
Of course,
and if you get caught, you're going to pay a bunch of penalties. So, that's, fortunately, I haven't been in a position where I've had to look into the ramifications of that too much. Nobody's really asked me, hey, I'm paying my employees under the table, what's going to happen to me? But if you're paying them under the table, you better hope they're not reporting that as income, because then when you get caught and audited, you get penalized. So, it's kind of like Grayson Allen playing for Duke. He can throw all the elbows he wants if he doesn't get a penalty thrown on him.
Right.
Maybe he wins the game, but chances are he'll get a technical
So
foul.
basically what you're saying is if, as an employer, you decide to do dishonest acts, you better have dishonest people who are kind of co-conspirators.
Yeah, so
I'm just teasing.
every once in a while I'll get clients that basically say, hey, I know this is against the law, but can I get away with it? And what I will always tell these people is there's the ivory tower way that you're supposed to do things, and here's what the law says you should do. And sometimes in particular industries, there's the boots on the ground, practical way that the industry actually runs. So they'll say, none of my competitors are doing this, so I can't compete if I follow the law.
Right.
And I tell them as their attorney, well, I can't, I'm not making any moral judgments. I'm just telling you what the law says you should do, what the fallout is if you get caught, and then you decide how you want to run your business from there. And I'll never advise them not to follow the law, but sometimes in certain industries, there's norms that, sometimes people jaywalk. If they get caught, they'll get a ticket. So you just need to know what the ramifications are for failing to follow the laws, and you should know what the law is.
Okay, so let's talk about employment contracts. Big companies, executives, they've got very formal agreements, perhaps many pages. Small companies pretty much don't. I mean, what would be the guidelines when an employer really should start thinking about this, and is it for everybody, key executives? When do we use them, I guess would be the first question. From a practical
So
standpoint.
you brought up a good point. So there's executive employment agreements are more expensive to put together than your routine employment agreements because they're dealing with things like profit sharing bonuses and when those kick in, and attorneys have to get much more involved in coming up with the substantive terms and how it's going to work. There's a lot more to them. It's not crazy. We're not talking about thousands of dollars still. It's still a, it's not terribly more difficult than a routine employment agreement, but every employee that you have and every independent contractor should have a written contract because your most likely source of liability as a business owner is from your employees, someone who you discharged and they either say they were wrongfully discharged or you're withholding pay that I was entitled or you promised me this. And if you are the more sophisticated party, and sophisticated is a loaded term, but basically if you're the employer, they're going to hold it against you for not having everything in writing and a proper contract. And for even my attorneys, our employment agreements, we've got a little bit of extra language about how they're going to be bonused and stuff like that, but it's basically a 2 to 3 page form agreement that we use for all of our employees, and we plug in job descriptions and how they're going to be paid. And there's a couple key things you want in those. I mean, you want to make sure that you have a clear job description, what the expectations are of that person. You want to make sure that you know exactly how they're going to be paid, whether it's a commission, an hourly rate, a salary, so that they can't claim, hey, you offered to pay me such and such, and you only paid me this other thing, and now I'm suing you. You want to make it clear whether they're an employee or an independent contractor, even though that's not determinative. And the most important clause for me is an attorney fee clause that says that if someone sues you and they lose, they have to cover your attorney's fees. If you sue them and you win, you get your attorney's fees covered for. And
to discourage the frivolous.
It discourages frivolous lawsuits, and it makes meritorious lawsuits economically feasible. So I always assume that my client isn't the one that's going to do something illegal or breach the contract. So we want to make it easy for them to sue somebody else with low damages if somebody else does something wrong. We want to make it hard for the employee to sue them for something frivolous, because that's where there's usually a lot of frivolous lawsuits, and that gets dissuaded with an attorney fee clause.
So then, often part of an employment agreement, sometimes a separate agreement, are non-compete agreements. And one of the things that I think makes them harder to enforce, I understood somewhere that an agreement can't prevent somebody from earning a living. So if I'm a mechanic and I'm fixing cars for you, and for whatever reason I leave that employee, you can't really prohibit me from fixing cars for somebody else. Maybe you could prohibit me from soliciting your clients, but how does
let me explain how that works. So there's a couple key clauses that these are kind of boxes we check and we try to figure out whether the client wants them. It doesn't belong in every employment agreement. It doesn't belong in every independent contractor agreement, but it's something I always talk about, and it's something that's often important to a lot of employers. So a non-compete clause, a non-solicitation clause, a non-disparagement clause, and a trade secret / confidentiality clause. Those are kind of the 4 big restrictive covenants. And I'll kind of explain what each one of them does.
Please.
So the easiest way to start is the difference between a non-solicitation and a non-compete clause. A non-solicitation clause says the employer, have these clients that are already working with me, and I have these employees that are already working with me, and you, employee, for a period of 2 years after the termination of your employment for any reason, cannot cause these employees to leave my employ. And I like to cause the employees to leave my employ or solicit customers that are already working with me. And it can be narrowly tailored to say, you just can't call them up and try to get them to come with me. Or, if I'm representing the employer, I want it to say, you just can't do business with any of these people, period, regardless of how they get to you. And the flip side of that is a non-compete clause that says, you employee, if you leave my employ for any reason, can't do this particular type of work within X amount mile radius for Y number of years. So 2 years usually holds up. If it's the problem with a non-compete clause is that if it's too broad, then the court can strike down the whole clause and find it the court won't necessarily narrowly tailor it to what would be enforceable. So you need to have an attorney draft this to make sure that it's something that's going to be enforceable, and it's enforceable if you're protecting a legitimate business interest. And that's the rule of thumb. So there's 3 things you want to see. You want to see that it's something that your company actually does and something that your company is actually, customers your company is actually competing for or planning to compete for. It's got to be, and part of that is being in the right geographical area. So, you can say all of the United States, but you better be doing business in all of the United States if you're going to put that in there.
Right.
You can say state of Illinois, you better be doing business in all of the state of Illinois if you're going to put that in there. Well, most people, what will hold up is something like a 5 to 10 mile radius. And so for people like lawyers, actually lawyers aren't allowed to have non-compete clauses, but dentists, doctors, it's typical to be 2 years, 5 mile radius. For someone like a roofing company that's doing business in all of Illinois, it might be the state of Illinois for 2 years. And anything past 2 years, it can be 2 to 5, but the longer the term, the wider the geographical area, the more worried we are about it getting struck down. A non-solicitation clause, on the other hand, which just deals with people that are actually doing business with you already, is much less likely to get struck down. And so just to quickly go over non-disparagement and trade secrets, it's pretty simple. Non-disparagement says that until the end of time, the employee or independent contractor can't say anything that damages your reputation in public, basically, and publishing information is just saying it to a third party. And trade secrets is basically we break down the type of information that we think is confidential in our industry, and we'll say they can't use this enumerated information or any other information that would normally be, give someone else a competitive advantage and isn't public knowledge. They can't use it for their own purposes. They can't give it to somebody else. So those are the protective things that you want to put in your employment agreement if you're in that type of industry. Now, if you're if you're running a fitness franchise and you're just bringing on people to work the desk, you may not have restrictive covenants in that. But certainly more specialized things like physicians, architects, engineers will want to have all those.
Relative to the non-disparagement clause, certainly, we don't want an employee to leave and have sour grapes and start spreading, wrong information about the company. Does it matter if there's something, there's truth in what they're saying? If, in other words, let's say employee leaves, somebody happens to be offered a job at that company, talks to them, and they say, I wouldn't work there. There's a lot of such and such going on. I wouldn't advise it. So does the truth of it matter at all?
This is different from defamation, which is something you can sue someone for in civil court. You don't need a non-disparagement clause to sue someone for defamation. Defamation is just saying something false that's damaging to your reputation, and for defamation, truth is a defense. So the fact that it's true is a defense. For a non-disparagement clause, it doesn't matter whether it's true or not. You can't say anything.
You can't say anything negative about the company.
Right.
Interesting.
Because your contract, you don't normally get that protection under the law. You have to have that in your contract for it to work.
Okay, so here's 2 scenarios. Scenario A, I'm looking for a job. Employer offers me a job. He sends me a formal offer letter, and it says on the bottom, accepted, and I accepted. Do we have an employment contract?
Well, it depends on the terms of the letter. So a contract it's not the title of the contract that makes a difference.
Okay.
It's what's in the contract. So if he says I'm making basically I'll tell you what a contract is. It's offer, acceptance, and consideration. And what consideration is you both get something out of the deal. So if I say I offer you this job and you say I accept, then you have a contract. Now, most employment agreements can be terminated at will. So he can immediately fire you and say, sorry, go take a hike, and you can't say we had a contract,
right?
Unless the offer letter says we're going to hire you for 2 years, and if you're terminated early, you get the severance pay.
Okay.
And it's not contingent on you working out a formal agreement. So something that we see is a letter of intent a lot in business law. And a letter of intent isn't a binding contract. It's just here's the terms, and now we're going to work out a contract.
Right.
So if it looks like a letter of intent where it says this is intended to be non-binding, even if it says 2 years and here's your severance if we fire you ahead of time, it won't hold up. But if it says I'm offering you this job, we're going to keep you employed for 2 years, and here's what we're going to pay you, and if we fire you early, we're on the hook for what we pay you, kind of like a coach. Then if you accept it, that's a contract.
Okay, here's scenario number 2. I start a new job. Somebody, maybe from HR, gives me a little booklet. Hey, these are our company work rules. Mm-hmm. And there's a form that I got to sign on the back acknowledging that I've received it. Was there a contract?
So you are bound by those rules. So employee, and you're doing a great job interviewing me. You're one step ahead. Employee handbooks are really important, and anyone who's got more than a couple of employees should have an employee handbook, because your employment agreement isn't going to have necessarily your vacation policy, your anti-discrimination policy, your anti-sexual harassment policy. It basically lays out all the rules for how they're expected to behave as an employee, all the benefits they're going to get, how they take vacation days. And for an employee handbook, you really do, to enforce any of it, you need them to say they've read it and sign it. And if you have it signed, then they're bound by those terms. Now, usually in an employee handbook, it's not something, you're not going to have pay terms or anything like that. It's basically going to be things that you can terminate them for if they violate it, and lay out a disciplinary procedure. And the reason that's important, you can terminate anybody for any reason or no reason at all. You can't terminate for discriminatory reasons. So you want to make sure you lay out a disciplinary process that everybody follows, and
Sure.
When they say you terminated me because of my race or my gender or my age, you could say, well, you violated this part of the employee handbook, and we followed the disciplinary path. The other thing is that unemployment insurance is a big concern for employers, and if you terminate someone without cause, and cause isn't, they ran in, it's really hard to prove cause. They've got to do something really bad for it to be termination with cause. If you terminate them without cause, then your unemployment insurance rates are going to go up in your payroll. And so basically the way we protect that is to have that disciplinary process to say, no, I terminated them for cause. Everything's laid out in this employee handbook. Here's what they did wrong. We followed the process. They got written warning, and now they're gone.
I'm going to tell you, this is going to be probably a wrap-up, but I'm going to tell you a story, and then you can comment on it. But many years ago, I was working for a relatively smaller company, and of course, many years ago, we didn't have as much concern for all these crazy laws and liabilities and everything that we have. But I was getting frustrated because we'd always handle situations differently depending on who it was. So what I did to start creating an employee handbook is I just started keeping sheets of paper in a folder about what we did in certain circumstances. When I thought I had enough, I then drafted an employee handbook, and then we kept on updating it. And the reason I tell that story is I know a lot of people, smaller businesses, perhaps, oh my God, now I got to do an employee handbook. Well, you could do a major effort at it, or you could do a minor effort and kind of let it evolve, but get started. What's your take on that?
Yeah, so what you did is a lot of work, and in that day and age, it was probably the easiest way to go about doing it. These days, if you want an employee handbook, go to an attorney or an HR specialist, maybe even your payroll company, and they will either provide you with, hey, here's our basic template, here's a couple options to pick from. Here, what do you want
there's models out
yeah,
there.
what do you want your holiday policy to be, A, B, or C, or something different? Or they'll have a checklist where you basically fill out a questionnaire and we plug in the employee handbook. So, I wouldn't try to create it out of whole cloth, because this is something that's been tried and tested by thousands of businesses, and there's a basic set of policies that most businesses follow.
And
so
I would think, most payroll services probably have something, and professional employment organizations and things.
To be honest,
like
you can even get them online.
Yeah.
I would always have an attorney, wherever you get them, whether you get it from your payroll service or online, have an attorney look it over, review it, make sure that and complies with the law and it's not internally inconsistent, we can check some boxes and it's not very expensive.
Okay, so last question and then we'll wrap up. So let's say somebody's listening to us and watching us or whatever, and that's a really good idea, and they need an attorney to look at some of this stuff for them. Do you know a good attorney you could recommend?
Yeah, so at O'Flaherty Law, we've got 5 attorneys. Between the 5 of us, we do just about everything. I do our business work personally. So, if you hire us to review your contract or set up your corporation or draft a contract, it's going to be me at the very least overseeing it. Usually I draft most of it myself. We're really efficient at it. We've been doing it for a lot of years. We treat your money like it's your own. So, and the other upside is that we have other attorneys that work with us on our staff that can handle other issues that come up. So if your business is going through trouble and you need a personal bankruptcy and to close up a corporation, we have a bankruptcy attorney that can help. We have a litigation attorney, an estate planning attorney, immigration, real estate, you name it.
So I'll give you a little plug here, and I'll tell everybody that I've known a lot of attorneys, and I know a lot of attorneys, but I think one thing that differentiates Kevin is he's also a master networker, and so not only can he help you with your legal issues, but he can help you with other resources. He can introduce you to people via his networking events. So I would encourage you, even if you don't have a pressing legal issue, still schedule a time with Kevin, get to know him a little bit, and there may be other things he can. And he's an interesting guy.
Well, I did an article on why you should use an attorney when incorporating your business, and one of the main reasons is just to establish a relationship with somebody, so that when you have a question, you just call up and have a 5-minute phone call. Because when you're a business owner, you just need a resource, and it helps to establish that at the outset. So, Jim, thanks for interviewing me.
No problem.
This was a blast being on the other side of it.
So
you did a great job.
How do people get a hold of you? Website, phone number?
Sure.
What's the easiest?
Well, we offer free consultations. Give us a call at 630-324-6666. Go to learn-about-law.com for blogs, podcasts, and videos on almost every legal topic. Go to seizeyourbusiness.com for videos and podcasts for business owners. So this was a combined one. So if you're a Learn About Law listener, check out Seize Your Business. If you're Seize Your Business, check out Learn About Law. Before I let you tell people how to get a hold of you, Jim, I want to thank Tom Weiler from Weiler Studios for doing our video. He does a great job, and he does videos for business owners. So you can go to Weiler Studios with a Y.com, weilerstudios.com, to hire him and check out his work. So thanks for that, Tom. And Jim, how can people reach you?
Yeah, you can reach me at 630-272-3895. Once again, I sell supplemental cancer insurance. Your basic insurance is not enough if you get cancer, and our programs are unique because we give you your money back if you never need the coverage. And then lastly, if you have somebody in mind or if you yourself would like to be a guest on our show, please give us a call, and we will do our best to make that happen. So thank you, everybody.
Thanks for listening.
All right.